Hi, my name is Ashley Minton. I'm an adjunct professor at IRSC in the class of BUL 3130. I also am a practicing attorney in the area of employment discrimination, and that's what I'm here to talk to you about today, employment discrimination. Okay, so pardon me if I'm reading a little bit, but I'll do my best to not read the whole time. Employment discrimination is prohibited by federal and state statutes with broad-based definitions, encompassing workplace-related discrimination that includes the hiring process, treatment of employees in terms of promotions, donations, work schedules, working conditions or assignments, and also disciplinary actions. The main body that governs employment discrimination, or that oversees it and or enforces it, is the Equal Employment Opportunity Commission, otherwise called the EEOC. This is the administration agency charged with carrying out federal workplace anti-discrimination laws through using its rulemaking authority, investigatory powers, and enforcement action as necessary. As a practical matter, the EEOC can pursue only a fraction of claims, obviously because there's so many claims that are submitted to them every year that are made by employees where those actions have some important legal significance, or where the employer's conduct was particularly egregious or in bad faith. We'll talk a little bit more at the end about how to practically file a claim with the EEOC and what happens with that, but we'll just put that on pause for right now. Okay, so we're talking about the workplace. The primary federal, and again I'm saying federal, not state, because each state, as well as also local jurisdictions such as, St. Lucie County, Martin County, can have different ordinances or laws or statutes. What we're talking about here is the federal statutes. The main ones for employment discrimination that we're going to talk about is Title VII of the Civil Rights Act, the Anti-Discrimination in Employment Act, the ADEA, and the Americans with Disability Act, the ADA. These statutes can be categorized as either laws that require the person in the protected class to receive equal treatment as non-class members, or laws that require the person in the protected class to receive special treatment. Okay, so let's first talk about Title VII, which is obviously the big one when you're talking about employment discrimination. Title VII of the Civil Rights Act of 1964 applies to any private sector employer. Again, note, it's private sector, not public sector. Employer with 15 or more full-time employees. Also note, you need 15 or more full-time employees. That's important. As well as labor unions, employment agencies, state and local governments, and most federal government employers, and prohibits discrimination in the workplace on the basis of membership in what's called a protected class. So what is this protected class? Title VII or any other anti-discrimination laws, statutory protection is only extended to those who have been discriminated against based on their membership in a protected class. And the plaintiff need not be a minority of the protected class in order to be covered. So the big, the only protected classes that Title VII includes are race, color, national origin, gender, pregnancy, and religion. Note that when I say sex, or gender, when I say gender, I'm referring to sex, meaning male or female. A lot of times the book or other cases will refer to it as sex discrimination. When it's saying sex discrimination, it's referring to gender, meaning male or female. What Title VII does not cover, and this is important to note, and there is no federal law at this time that covers discrimination based on sexual orientation. Again, there is no federal law that makes sexual orientation a protected class. There are some states that have it and some local municipalities that have added non-discrimination clauses to include sexual orientation as a protected class. But as far as federally, sexual orientation is not a protected class, and at this time an employer can discriminate based on the fact that someone is a member of the LGBT community. If you're a lesbian, the employer can say, well, you know what, you're a lesbian and I don't hire lesbians, or, I just found out you're a lesbian and you work for me and I don't want you to work for me anymore and you're fired. That is not discrimination. It is not. It's not illegal conduct at this time on the federal level. Now, there has been, the Employment Non-Discrimination Act has been submitted in Congress. However, it has not yet passed. It was actually introduced in 1994, and now in 2012, we still have not been able to get it passed. Our current administration states that they support ENDA, however, it has not been passed. So again, at this time, on the federal level, sexual orientation is not a protected class. You need to know that. It's very important. Okay, there's three general different theories of discrimination. The first one is disparate treatment. The second one is mixed motives. And the third one is disparate impact. And we'll talk about each of these in turn. So let's talk about disparate treatment. That is overt and intentional discrimination, and it occurs when an employer treats an employee differently based on a membership in, again, a protected class. And the book talks about the McDonnell-Douglas test. A plaintiff must make out a prima facie. Again, that's Latin. There's a lot of Latin in the law. It's pronounced prima facie case, showing 1, membership of a protected class, which again, we already know what they are because Title VII tells us. 2, that the plaintiff was qualified for and applied for a job. And 3, was rejected. And 4, the position was filled by a non-protected class member. Though that's what's called the McDonnell-Douglas test that you need to use under disparate treatment. In cases involving other types of discriminatory action unrelated to hiring or promotion, the appropriate prong is adjusted accordingly. Second, after you do that, if the plaintiff can make this prima facie showing under all 4 of those sub-prongs that we just discussed, the burden then shifts to the employer to show a legitimate non-discriminatory reason for the action. And if the employer can do that, the burden then shifts back to the individual, the plaintiff, to show the reason given by the employer was not the actual reason for their action, which is oftentimes difficult to do because it's often difficult to nail down what the actual reason was for that the employer is citing as their non-discriminatory reason. If you have it in writing, obviously, it makes it a lot easier, but the fact of the matter is most of the time you're not going to get that in writing. It's going to be very difficult to meet that burden. Okay, so let's talk about mixed motives. Mixed motives, the mixed motives theory articulated in Price Waterhouse v. Hopkins. And just so you know, in Price Waterhouse v. Hopkins, it was a 1989 case that went up to the United States Supreme Court, and it addressed a claim brought by a lady by the name of Ann Hopkins, who sued for sexual discrimination because she was not offered a partnership in her accounting firm despite the fact that she had exemplary work records. She was told by upper-level management that her chances of getting a partnership would improve if she, and I'm reading because I want to quote this exactly, if she would, quote, walk more femininely, talk more femininely, dress more femininely, wear makeup, have her hair styled, and wear jewelry. That's what happened in Price Waterhouse. The United States Supreme Court held that that was discriminatory behavior. Again, discriminatory in that she belonged to the protected class of, gender, under gender or sex, and she's a female. She was being treated differently than males. Under this theory, the employee must prove that membership in a protected class, again, the gender or sex class, was a substantial factor in the decision-making process, which clearly it was in Price Waterhouse. That's the reason why she was denied partnership, and she was told she could get a partnership if she just did those things and acted more like a lady. And the burden then shifts to the employer to offer evidence that it would have made the same employment decision regardless of the membership in a protected class. Clearly that would be difficult for them in Price Waterhouse v. Hopkins because there were several witnesses, I think, and even some documentation, I think, that showed that she was being discriminated against based on her gender, which again is a protected class. The next theory is the disparate impact. The disparate impact test articulated in Griggs. And Griggs was a case, Griggs versus Duke Power Company, I think it was back in the 60s, where they were giving IQ tests to people in the labor department and saying that their laborers would have to have both a high school diploma and get a certain score on an IQ test. What happened was this was disproportionately or disparately affecting African Americans who at the time did not have as many people working in the company that had high school diplomas and or could get a high enough score on the IQ test. What was shown in that case is though the IQ test and or having a high school diploma was not substantially related enough to performance in the labor department to be any test that would be meaningful or necessary in that context. And it disparately impacted African Americans over and above whites or Caucasians. And the fact of the matter was in Griggs, a lot of the whites, that were working in the labor department at the time didn't even have the high school diploma and or didn't score high enough or didn't even take the IQ test. So clearly that was a false a motive that the Griggs or the Duke Power Company was purporting to say that was the motive that they were using, but it really wasn't. What Griggs say, it prohibits an employer from using a facially neutral practice. And again, an IQ test, appears facially neutral. It appears like, okay, you take a test, you get X score. It's not racist in any way. However, it prevents an employer from using a facially neutral practice that has an adverse impact on members of a protected class. And again, African Americans, which Griggs is a member of a protected class, i.e. race. Under the disparate impact theory, a plaintiff must prove that the evaluation methods resulted in statistically significant differences that adversely impacted members of the protected class. And despite EEOC guidelines that define adverse impact statistically in federal court decisions, disparate impact is still a very thorny area of discrimination law. Because, again, you could impose some regulation or some, bar that somebody has to set and, do it in a facially neutral way. However, it can, again, have a disparate impact on the testing category or the group. Okay, so those are three of the main areas. Now let's move on to sexual harassment. What is sexual harassment? It's unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature that are considered violations of Title VII if the conduct is, number one, in the context of explicit or implicit conditions of an individual's employment or as a basis for any employment decisions, i.e. quid pro quo, which is, again, Latin. It means this for that. Or two, unreasonably interfering with an individual's work performance or creating an offensive work environment, otherwise known legally as a hostile work environment. A lot of things that the courts are going to be looking at in sexual harassment cases, it's two things that they're going to use kind of as a balancing test. One is the severity of the harassment, and number two is the pervasiveness of the harassment. So if the harassment is very severe, and taking it to the most severe, where this has actually happened, someone will be raped at work. That is pretty much, as severe as it gets. That only, as far as pervasive goes, is how many times it happens. If it's so severe, but it only happens one time, it's going to be sufficient. However, if it's, catcalling or, hey, baby, give me some sugar, something like that, the severity of it, again, it's wrong, but the severity of it isn't actually that high. So it happening one time is probably not going to be sufficient enough. If the severity level is low, it's going to need to be pretty pervasive, meaning it happened on multiple different occasions. So keep in mind those two things. More recently, the United States Supreme Court has developed sexual harassment doctrines related to liability of an employer for harassment committed by the victim's coworkers or supervisor, and has also made clear that sexual harassment prohibitions apply to same-sex harassment. So don't just think it's male on female or female on male. A lot of the times in the workplace, sexual harassment will actually be same gender on same gender, which is female on female or male on male. And the case that's really the seminal case for that is Oncal versus Sundower Offshore Services. That case went, again, all the way up to the Supreme Court and concerned a guy by the name of Joseph Oncal who worked at an oil platform in the Gulf of Mexico, which I imagine is a heavily male-dominated profession, and was forcibly subjected to sex-related humiliating actions against him by members of the 8-man crew, physically assaulted in a sexual manner, and threatened with rape. Noting that male-on-male sexual harassment was assuredly not the aim of Congress when it passed Title VII, Justice Anton Scalia noted that statutory prohibitions often go beyond the principal evil to cover reasonably comparable evils, and it is ultimately the provisions of our laws rather than the principal concerns of our legislators by which we are governed. So even though Title VII hadn't really contemplated, at the time of its being passed in the 60s, it hadn't really contemplated same-sex sexual harassment. The court said in Oncal, look, even though they didn't intend that, we're going to expand it to include that. So don't think that, if you're in a job and it's male-on-male harassment, and, a lot of the times that happens in playful or joking manner. Think about football players, smacking each other's backsides. It happens in a jovial, joking context, but that's still sexual harassment, and you can still get sued for it or be sued for it, and you can still sue for it. Okay, so what are the remedies for sexual harassment? Title VII provides for various remedies, including injunctions, reinstatement, compensatory damages, retroactive promotions, and remedial actions by the employer. Punitive damages are available only when a plaintiff proves that a private employer acted maliciously, in retaliation, or with reckless disregard to the employment discrimination laws. Another component of employment discrimination is age discrimination, and it's the Age Discrimination in Employment Act, the ADEA. It prohibits employers from discriminating against employees on the basis of their age if the employer, and this is a big one, is 40 years old or over. The employee has to be 40 or over. It's not going to be age discrimination to say, I didn't get the job because I look too young for the job, and I'm not in the 40 and over category. I hope you guys don't put me in that category. I'm not there yet. And I say I didn't get the job because I look too young. I'm not going to be able to get any remedy under the ADEA because I'm not 40 and over. You have to be 40 and over to even come under that law. Two, satisfactory in job performance. So you can't be failing in your job duties or getting negative reports and then try to get any kind of satisfaction under this law. You have to be doing a satisfactory job. 3, adversely affected by the job action, and 4, better treatment is given to someone substantially younger. You're seeing a lot of these types of lawsuits coming up now because what happens is people in senior positions are often older because they've been with a corporation for a longer amount of time. And then what will happen is they'll be doing well in their job and they'll get fired or released, and they'll bring in a younger person to replace them in their job. Because the younger person is going to do the same work, maybe better, maybe not better, for a lesser amount of pay. So you have to look out for that. But again, you have to meet those 4 criteria to even get any kind of satisfaction under that act. Next, if the employer makes a prima facie case, then the employer must present a non-discriminatory reason for the adverse employment action, at which point it is up to the employee to convince the fact finder that the reason the employer gave is pretextual and the real reason is age discrimination. Substantially younger requirement. Many courts follow the general rule that the age difference must be at least 10 years in order to qualify as substantially younger in asserting an age discrimination claim. So if I'm 41, I'm trying to get some kind of justice or some kind of accord and satisfaction under this act. I'm 41 and the new person that they bring in is 36. Generally, it's going to be a no-go for my lawsuit because that new person is not substantially younger than me. Disparate impact claims under the ADEA, articulated in Smith v. City of Jackson, Mississippi, provide that the employer's burden to show the reasonableness of the business practice at issue is minimal. So their burden to provide the reasonableness for this job practice of firing, the plaintiff and hiring this new younger person is minimal. That burden is minimal. So these types of cases are actually pretty difficult. The next act that we're going to talk about is the Americans with Disabilities Act. The ADA, passed in 1990, seeks to eliminate discriminatory employment practice against disabled persons by requiring that employees with 15 or more employees, again, note 15 or more, make reasonable accommodations that allow the disabled employee to perform essential job functions, so long as accommodation does not cause the employer to suffer an undue hardship. Documented disability requirement. The ADA defines disability in terms of individuals that have physical or mental impairments that substantially limit a person's ability to participate in major life activities. In 1999, the Supreme Court narrowed this list of disabilities and what ones were covered under the ADA, and ruled that any condition that could be corrected was not a disability covered by the Act. However, in 2009, the ADAA was passed, which is the ADA Amendments Act of 2008, that passed in 2009. It expanded the definition of disability with specific statutory definitions intended to urge the courts to interpret the definition of disability in favor of broad coverage rather than what the Supreme Court had done in narrowing the coverage. It's regarded as test, even if an individual does not meet the definitional requirements of a disability under the ADA. Employees may still be protected by the ADA when the employee was regarded as having an impairment by her employer, even if the impairment was not actually a disability. So if the employer treats you like you have a disability, even if your disability or impairment is not one that's statutorily defined under the ADA or ADA, you can still get a remedy under the ADA if your employer treats you like you have some type of disability or impairment. Reasonable accommodations. What are reasonable accommodations? The ADA states that reasonable accommodations may include making existing facilities readily available to individuals with disabilities, and 2, job restructuring, part-time or modified work schedules, reassignment to vacant positions, and the provision of readers or interpreters if those are needed. The statute does not require the employer to provide accommodations that constitute an undue hardship on the employer. An undue hardship is one that is defined that will result in significant difficulty or expense in the context of the overall resources of the employer, the number of persons employed, the effect on expenses or resources, or the impact of the accommodation upon the operation of the facility. This is a lot of the times where lawsuits under the ADA fail, is that the accommodation that the plaintiff is requiring or asking the employer to make is something that would be an undue hardship, either financially or just practically, on the business in relation to the amount of employees that it has or its resources or finances. So this is that's a major point for defendants in ADA actions. This is usually where the plaintiff's case falls apart, is the undue hardship on the employer. Okay, so on to the Equal Pay Act. The Equal Pay Act, the EPA, makes it illegal for employers to pay unequal wages to men and women who perform substantially equal work unless the difference is based on a factor other than gender. Just so you know, it is fact that women to this day in 2012 still make 70 to 77 cents on every dollar that a man makes for the substantially similar or exact same work. That is a fact. It's not, something that someone made up. It is statistically proven that women are still making 70 to 77 cents for every dollar that a man makes. To that end, in 2009, Congress passed the Lilly Ledbetter Fair Pay Act, which effectively reversed the United States Supreme Court's decision in Ledbetter versus Goodyear Tire and Rubber Company, and seeks to ensure that employees subject to discrimination have the opportunity to challenge every discriminatory paycheck that they have received. In Ledbetter versus Goodyear, what the court did was say that look, your time for filing these actions or these claims that you're being discriminated against, you're not getting equal pay, arises from the time that you start getting the unequal pay. What that case did, though, is actually effectively block a lot of plaintiffs' access to any remedy under this act, because a lot of the times what will happen is you won't find out that you're getting unequal pay or discriminatory pay until much longer down the line, much past the 2-year deadline. So if that's the case, then you're stopped from actually getting any remedy under this act. What the Lilly Ledbetter Fair Pay Act did was say, no, we're not going to do that. We're going to make the statute of limitations or the time to get any remedy under this act start tolling from the time that you find out about the unfair pay or the discriminatory pay. Just so you know, that's been a little bit of a contentious area with the presidential elections coming up, with Democrats on one side and Republicans sometimes on the other, sometimes siding with the Democrats, stating that some Republicans at least, have stated that they do want to repeal the Lilly Ledbetter Fair Pay Act and have called it a nuisance. Okay, so we've talked about all this discrimination, and now you know what it is, how you have to prove it, but practically, what do you do when you're an employee in a situation and you think that you're getting discriminated against? Firstly and foremostly, I always recommend that somebody seek legal counsel regarding any questions of employment discrimination. Generally, any attorney will give you a free consultation to speak with you about whether you have a good employment discrimination case or not. What generally will happen at that point in time, you can either initiate yourself or through a lawyer, is the aggrieved party, meaning the employee who thinks that they've been discriminated against, needs to file a complaint against the employer with the local office, and ours is in Miami, of the EEOC, generally within 180 days of the adverse job action, at which point the EEOC commences a preliminary investigation. Filing this, formal complaint with the EEOC is actually a lot easier than you would think that it is. What you do is you just send them a letter, and the letter describes with particularity, with as many dates, names, etc., evidence as you can muster in the letter, describing, again with specificity to the EEOC, what you think that the employer has done wrong, how they've aggrieved you, and how they've discriminated against you. What will happen then is an investigator or person working for the EEOC will then type up a formal complaint. They do that for you. They will type up a formal complaint, and they will send that back to you to proofread, to make any corrections necessary, and ultimately to sign and approve if it's correct. You sign that, you approve it, you send it back to the EEOC. The EEOC will keep investigating. If they find that your claim has merit, what they will do is they'll seek out the employer, and they're required by statute, the EEOC is, to engage in conciliation negotiations in an attempt to settle the case. So what will happen is they'll get with the employer, and they'll ask the employer if they want to go into mediation. They'll also ask the employee, do you want to mediate? Generally, there's no harm in mediating. So as an attorney that represents discriminated against employees, I always go to mediation if the employer will agree to mediation. What happens in mediation is each side tells their side. There's a mediator from the EEOC that's provided that is a go-between between both of the parties. You can either all sit in one room together around a table, which is oftentimes a little bit awkward because your client will have been saying that the employer, who's oftentimes sitting right across from them, will be the person who discriminated against them. So a lot of times that's uncomfortable for an employee, and I can understand that. So what happens in those types of cases, if my client or the employee does not want to sit across from the person that discriminated against them or the person that represents the company that discriminated against them, what you do is you ask for an immediate caucus, which is where both parties go in separate rooms with their counsel. So I would go in a room with my client, and the employer would go in a room with their attorney if they've so brought an attorney. You don't have to have an attorney at these things, and oftentimes employers will not pay for an attorney's services, hoping that they can get the case thrown out or mediate it for some nominal fee, and then they won't have to expend the money on hiring an attorney to attend mediation, because a lot of times in civil cases, attorneys are charging anywhere from, say, about $250 an hour on the low end all the way up to and including $450, $500 an hour. So as you can imagine, these things can get pretty expensive. Mediations can go on all day, multiple days, and actually you can mediate by email as well, and that can extend the process months. So it can get pretty expensive pretty quickly for the employer. For the employee who retains, an attorney, generally attorneys work for the employee on what's called a contingency basis. So they're just going to take 33 1/3, generally, with some caveats. They're going to take 33 1/3 of whatever's recovered. So that generally works out well for the employee, because even if their attorney, the employee's attorney, spends 10 hours in mediation, the employee's not paying for that out of pocket, and they're not paying them by the hour. They're just getting, their 33 1/3. What will happen at mediation is then both parties will go back and forth about, what they want. With the employee starting at, the top, and generally the employer starts at the bottom. And hopefully at some point in time they will meet in the middle. Sometimes it happens in mediation, sometimes it does not happen. If it does not happen in mediation, the EEOC will issue you a letter called a right to sue. And then once you get your right to sue letter from the EEOC, it's time to commence a lawsuit against the employer if you were not able to mediate it. Obviously, that gets exceedingly expensive to actually litigate it in court. So it's a lot of times easier for the employer and the employee, actually, to be able to settle the case in mediation. And that actually happens with great frequency. I also want to say that sometimes the EEOC might not take any action at all if they find that you don't have a valid complaint. And if you don't have a valid complaint, again, they'll give you a right to sue letter. But if the EEOC has rejected your claim, most attorneys will not take the right to sue letter and take your case and sue the employer if the EEOC hasn't found any basis for your claim. Again, like I said, after 180 days have passed from the time of the complaint, the employee may demand that the EEOC issue this right to sue letter, entitling the employee to file a lawsuit in a federal court. But again, it's advisable to try to settle these things in mediation. It makes it go a lot quicker. As you know, civil suits can take years. That's not an exaggeration. To take a case from commencement to trial in a civil case in a year would be at a breakneck speed in a civil case. In a criminal case, that would be, a really long time. But in a civil case, that's the low end of the spectrum. I've certainly had civil cases that were what I would call extraordinarily simple cases that, were 6-7 years old when they came to me, just because, I don't know, attorneys not, making it go faster or what, but that happens in civil court. So it could take years to get any pay or any money or any, damages from the employer to under the EEOC and under filing a suit. A lot of times it's more beneficial to just, come to some decision in mediation. Even if it's not exactly the amount that you are looking for, it's better to have, two birds in the hand is worth, a bird in the hand is worth two in the bush, as they say. It's better to have it right then, because a lot of times people pursuing these complaints have actually been either fired outright or what's called constructively discharged, which your book discusses, and they don't have a job at the time. So money becomes actually a really important factor. Okay, so what about the employers? I've talked to you a lot about, what you do as an employee. What do you do if you're the employer and you get a complaint from the EEOC or you get sued for employment discrimination in some way? What do you do then? Though each anti-discrimination statute has its own set of legally recognized employer defenses, there's some level of commonality amongst all these defenses, which I'll discuss with you briefly. The first one is business necessity. It's a broad defense to employment discrimination, and it's used when a business can justify discrimination on the basis that it is legitimately necessary to the business operations of the company. For example, if I operate an accounting firm and I have a requirement that I only hire employees with an accounting degree, that's a business necessity for that area, for that particular business. Even if by saying I require all my employees who are accountants for my accountant firm to have an accounting degree, it disparately impacts a protected class, say women, because me requiring people to have this accounting degree, there's not as many women as men that have that, and I'm just using this as a hypothetical. I don't know that that's true. In fact, it may not be true, but I'm just using it as a hypothetical. If less women had that degree than men, it could disparately impact women. It wouldn't matter, because my defense as a business is, look, it's a business necessity. I'm an accounting firm. I have to have accountants with accounting degrees. Or no one's going to hire my firm if I have people with, just high school diplomas doing people's, accounting. The next one is, and this is a big one and a little bit tricky to understand or sticky to understand, which is bona fide occupational qualifications, referred to in short as BFOQs. Federal anti-discrimination statutes allow employers to hire and employ on the basis of religion, gender, or national origin in certain instances where the classification is a BFOQ that is reasonably necessary to normal operation of that particular business or enterprise. For example, employment of clergy. Certainly if you're a Catholic church, one of your requirements for employment for a clergy person is going to be that they're of the Catholic faith. You're not going to be able to hire an atheist to be a clergy person in your church. You're not going to be able to do it. It's a bona fide occupational qualification. Likewise, on BFOQ cases that are unclear, the employer must prove that members of the excluded class cannot safely and effectively perform essential job duties. Gender, there are times, say you're in a stage production or you're an actress and the role calls for a female part to play a female role. You're not going to be able to be a man and get that role and then sue under discrimination because it's a bona fide occupational qualification, a BFOQ, that the person, seeking that role is actually a female. Another defense is seniority, a defense for employers using a seniority system as the basis for certain job decisions if the seniority system is based on objective elements of seniority and the employment decisions are made in good faith and pursuant to that established objective system. So you can use the defense of seniority. The last defense that I want to discuss with you is employee misconduct. When an employee commits an act of misconduct, so long as that act has been identified to the employee as misconduct, employers may discipline the employee in accordance with the company's general practices without liability for discrimination. I had a client come visit me one time who wanted to sue his employer for discriminating against him based on the fact that he was fired. He belonged to a minority race. He was fired, and a white person was hired to replace him. However, on his termination paperwork, it stated that he had stolen things. So regardless of whether, it was discriminatory or not discriminatory, which is, questionable, even that question, I wasn't certain about that. But there was certainly employee misconduct. That is a defense for an employer to say, look, even if it is discrimination, which, again, they're never going to admit that. There was employee misconduct, and I can fire the employee. I have the right to fire them, and understand in Florida we're a right to, a right to work state and at will employment. So your employer employs you at their will, meaning they can hire and fire you for whatever they want, so long as it's not a discriminatory reason. And finally, state anti-discrimination statutes. Again, each state has its own statutes that are often modeled after the federal statutes and have their own administrative agencies charged with enforcing and adjudicating discrimination cases. State anti-discrimination statutes sometimes differ, though, substantially from federal laws in two ways. One, state statutes tend to cover more employers, with some statutes imposing anti-discrimination statutes on small businesses with just one employee. So while I said, most of the federal laws were applied to employers with 15 or more employees, a lot of state statutes actually, make their statutes much broader and say, no, these are going to apply to employers with even one or more employees. So you need to be mindful about the specific statutes in your state, in the requirements of your state. And then secondly, some states have expanded protected class membership, most notably to discrimination based on sexual orientation and or gender transformation, which we talked about a little bit earlier. Some states have passed acts or statutes that relate to whether you can discriminate or not based on sexual orientation. And again, there is no federal law making sexual orientation a protected class at this time. So I hope you enjoyed it. I hope you understand employment discrimination a little bit better. If you have any questions about employment discrimination, please give me a call and let me know. For those of you that aren't in my class, my number is 772-465-0029. If you'd like to talk about employment discrimination, anything in the text, I'd be happy to talk with you about it. It's an interesting and complex area of the law that employers and employees both need to know inside and out so that you know your rights and you can enforce your rights appropriately. Thank you.